Kwekwe, Tansei, Ulukut, good morning et bonjour. I first want to acknowledge that we are here today in Ottawa on the traditional territory of the Algonquin Anishinaabe people. I'm here with Chief Medical Officer of Indigenous Services, Tom Wong, and Associate Deputy Minister, Valerie Gideon. I will start by giving you an overview of the numbers once again for vaccinations. As of June 7th, we are aware of 687 Indigenous communities with vaccinations underway for a total of 540,581 doses having been administered. This corresponds to over 80% of Indigenous adults having received a first dose and 72%, importantly, of people 12 and over. Based on StatsCan 2020 population projections, over 41% of eligible individuals in First Nations communities, as well as eligible individuals living in the territories, have received 2 doses of the COVID-19 vaccine, which includes, importantly, and I'll get to that later, individuals 12 years of age and older. As far as the number of cases as of June 8th in First Nations communities on reserve, we're aware of 838 active cases, rather 839, which is a bit of a decrease from last week. This brings us to a total of 30,479 confirmed positive COVID-19 cases. There are 29,292 recovered cases and tragically 348 deaths. There has been a bit of a jump based on a recent surge in Northern Ontario, particularly among the young, and I will get to that later. We know that this pandemic has been very tough on so many Indigenous communities across the country. La pandémie a eu un impact financier non négligeable. Ceci a entraîné des réductions des revenus autonomes pour de nombreuses communautés autochtones. Les revenus autonomes sont les revenus que les communautés tirent d'entreprises commerciales, parfois d'impôts fonciers ou autres activités, y compris la location commerciale et les recettes fiscales. En raison de cette réduction de revenus autonomes, de nombreuses communautés ont eu de la difficulté à offrir et ont été incapables de fournir des programmes et des services importants aux membres de leur communauté. Pour répondre à cette situation, l'initiative des revenus autonomes dans les communautés autochtones fournit un financement de 332,8 millions de dollars pour compenser en partie cette baisse de revenus autonomes. Cela permettra, entre autres, d'offrir un soutien aux communautés des Premières Nations, des Inuits et des Métis afin de continuer d'offrir des programmes communautaires de base et des services importants à leurs membres. Le programme est désormais offert à toutes les communautés des Premières Nations Inuit et Métis, aux Premières Nations signataires de traités modernes et autonomes, ainsi qu'aux conseils tribaux et aux gouvernements communautaires. J'invite donc toute personne intéressée à obtenir de plus amples renseignements en consultant le site web de Services aux Autochtones Canada pour savoir comment présenter cette demande. Now let's shift focus to take a look at some updates from across the country. In relation to my comments earlier about Northern Ontario, we are aware of and closely monitoring the COVID-19 outbreaks in Kashechewan, Fort Albany, at Attawapiskat First Nations in particular. Canadian Rangers and additional Canadian Armed Forces personnel are helping provincial vaccination authorities in various communities of the Anishinaabe Nation in Northern Ontario. They're working with logistics and general duty tasks as part of Operation Vector, which is CAF's support to the federal, provincial, and territorial governments for distribution of COVID-19 as well. The presence of the CAF in Ontario in response to a request for assistance to support the government in Ontario and Orange partners as they deliver first doses of the COVID-19 vaccine to community members aged 12 to 17 is particularly important given the relative age of the youth where the outbreak is occurring. Canadian Rangers are currently activated in Attawapiskat First Nation, Fort Albany, Kashechewan First Nation, and Long Lake 58 First Nation, Ontario, to provide help with COVID-19 response efforts in these communities. In Manitoba, they are facing challenges with high rates of infections and, sadly, as we've seen, additional deaths this past week. I know that Indigenous leaders in the provinces continue to encourage their communities to get vaccinated, and I continue to thank them for that. As an example, in Portage la Prairie, there's an Indigenous-led clinic that's been very successful, administering 1,900 doses so far. The clinic operates in a way that is culturally sensitive and inviting to Indigenous people, which is so important in building confidence. Artwork and Indigenous music at the clinic, as well as traditional medicines like sage and sweetgrass. Also, Indigenous peoples in the province are now eligible to receive their second doses of vaccine as long as they meet the minimum time interval between the doses. And based on Statistics Canada 2020 population projections, over 89% of eligible individuals in First Nations communities in Manitoba have now received at least one dose of the COVID-19 vaccine, and over 34% have received 2 doses of the vaccine. Au Nunavut, les jeunes de 12 à 17 ans seront admissibles à recevoir leur première dose d'un vaccin à compter du 15 juin. Il y aura des cliniques de masse à Pangnirtung, Pond Inlet et Clyde River. Vous savez, je l'ai dit souvent, mais je veux profiter d'une autre occasion pour remercier et reconnaître les dirigeants autochtones. Vous avez fait un travail exceptionnel, admirable tout au long de cette pandémie et en aidant vos collectivités, en assurant la coordination avec les responsables de la santé publique et en faisant face à une situation qui évolue rapidement avec résilience. Vous êtes allés au-delà de votre devoir. Comme toujours, je tiens à rappeler tout le monde l'importance de suivre les directives en matière de santé publique. Veuillez évidemment porter votre masque en public, éviter les grands rassemblements et lavez-vous les mains fréquemment. Miigwech, Nakumik, Marcy, thank you. Merci.
I want to acknowledge that I'm on the unceded territory of the Algonquin and Anishinaabe people. Since January, with the upsurge of the vaccine uptake in First Nations communities, we see the rate of active hospitalization dropping by over 70% and highlighting the importance of immunization in preventing serious outcomes associated with COVID-19. The recent extension in the eligibility for the vaccine from adults to youth ages 12 and up is a positive step in protecting a larger portion of the population. The more people receiving the vaccines, the greater the community protection. Also, vaccinating youth will contribute to the safe return to schools and other activities. La récente extension sur l'éligibilité au vaccin pour les adultes jusqu'aux les jeunes de 12 ans et plus est un pas positif pour la protection d'une grande portion de la population. Plus les gens reçoivent les vaccins, plus grande sera la protection pour les communautés. Aussi, la vaccination des jeunes va contribuer à un retour en classe sécuritaire et à reprendre leur activité. To that end, I'm pleased to highlight a few of the vaccination efforts that are underway in Ontario this coming week. First doses of the COVID-19 vaccine are available at Cambridge this week. Individuals 12 and up are eligible to register, and Indigenous immunizers and cultural supports are available. Niagara Public Health is running vaccination clinics tailored for youth and families beginning June 14th. Finally, I want to acknowledge the tremendous efforts of Indigenous leaders in protecting communities, protecting families, protecting elders, pregnant mothers, youth, and children. Miigwech, Nakumik, and Marcy.
Nous allons maintenant prendre les questions des journalistes, une question et une question de suivi. We'll now take questions from journalists, one question and one follow-up question. Operator, first question, please.
Thank you. Merci. Please press star 1 at this time if you have a question. S'il vous plaît, appuyez sur étoile 1 maintenant pour poser une question. There will be a brief pause while the participant register for questions. Il y aura un court délai pour permettre de vous enregistrer dans la file d'attente pour la période de questions. Thank you for your patience. Merci de patienter. La première question. The first question is from Brett Forrester, APTN News. Please go ahead. Your line is open. Votre ligne est ouverte.
Hello, everybody. Thanks for taking our questions today. My question is for Minister Miller. Regarding the Mushuam AFN class action, could you please explain why the government refuses to certify the pre-2007 Jordan's Principle claims, which is forcing that part of the class to litigate?
And thanks, Brendan. Perhaps this gives me an opportunity to speak to the motion, the non-binding motion that was introduced by the NDP and supported by the entirety of the House, and with the government abstaining. There are 2 other class actions that are currently underway that we want to resolve without a single child having to testify. And that is the goal of our government, to make sure that people are fairly, justly, equitably compensated. The motion on Monday didn't address these two class actions, which, if resolved properly, would result in those who have suffered most getting more than the CHRT could ever order. So foremost, as a government, I know there's been a lot of questions about why the government abstained. We were, for the large part, vastly supportive of the body of the motion. We know that complex legal cases shouldn't be resolved in the House of Commons in non-binding motions. I think people should examine that for a second. But the fact that these two class actions were left out as part of a complex legal dynamic, where the government has said that it will compensate children equitably and fairly, in my mind, is something that lacks integrity. And it's something that, as a government, first and foremost, when we talk about our relationship with Indigenous peoples, we have that duty to be forthcoming and tell the truth no matter what. And so I think that's my answer in relation to the abstention on Monday, because of the complex nature of the legal questions at issue, and even the potential that the government would be in contempt of court were it to apply the measures that were being demanded, albeit in a non-binding motion of us. So I think that merited some level of explanation. And as you know, Brett, the government has acknowledged the need to compensate children for the harms they have suffered and denial of services. One of them, these complex matters are before the court, and our job is to resolve them in a fair and just way.
Do you have a follow-up, Brett?
Yeah, thank you. I'm not sure that really answers my question. In this part of the class action, the proposed lead plaintiff is Zach Trout. Two of his kids died from a rare illness in the 2000s before they even reached age 10. They fell between the jurisdictional cracks, much like Jordan River Anderson did. What is your message to him and families like his who are having to contest their claims against the Crown?
Yeah, Brett, any of those discussions between us and the parties in question, I'm not going to use a public platform to discuss them at this time.
Thanks, Brett. Operator, next question, please.
Thank you. Merci. La prochaine question, the next question is from Jacques Galland, Toronto Star. Please go ahead. Your line is open. Votre ligne est ouverte.
Hi, good morning, Minister. This week, Library and Archives Canada has been removing content from its website that its own staff has said amounted to a deliberate and systematic exclusion of Indigenous people and Indigenous perspectives, including a rather glowing profile of Johnny MacDonald that mentioned nothing about his role in the creation of residential schools. Now, an Indigenous advocate has said that the government should launch an external review of the content that Library and Archives presents to the public. Do you think the government should launch such a review?
I think it's good that it is putting more nuance and context into these entries. As to a sweeping government review, I think I'd have to reflect on it further. I think as a government and as the forward face of things, particularly in terms of archival presentations, it's something that needs to be looked at. I would have some hesitation putting that in the hands of politicians, but to the extent we do have to look at the foot forward that the government presents, as well as Library and Archives Canada, I think it does merit some review at some level. But again, I hesitate in giving this answer, knowing that this should be in the hands of well-informed historians and not necessarily politicians.
Jacques, do you have a follow-up?
Yeah, I can understand the concerns around putting this in the hands of politicians, as you say, but I think what has been asked for is not a review by politicians. It's a review to be ordered by the government, but an external review to be led perhaps by historians, as you suggest. So I'm wondering, do you think that such a review is necessary, an external review of Library and Archives' content that it presents to the public?
Yeah, look, being the son of a historian who taught Canadian history for 45 years, I'm all in favor of historians taking a look at things.
Thanks, Jacques. Next question, please.
Thank you. Merci. La prochaine question. The next question is from Christy Kirkup, de Globe and Mail. Please go ahead. Your line is open. Votre ligne est ouverte.
Hi. Sorry, I wanted to go back to the NDP motion again, if we can, specifically around the orders from the Canadian Human Rights Tribunal. There will be some hearings coming up in federal court next week, and there has been no indication that the federal government is going to change course in terms of seeking a judicial review of those orders from the CHRT. Can you just explain why the government is proceeding on this path following the unanimous passing of the motion in the House earlier this week?
Yes, and thanks, Christy. In terms of a government that operates often through a party whip, to those members of Parliament that are supporting the government, I think it was important for them to freely express their view on the NDP motion. As the government with a particular duty that when in relation to Indigenous peoples, there is the honor of the Crown at issue, we have a duty foremost of honesty, and it's what I highlighted to Brett. The honest reality of one of those particular clauses within the motion, as non-binding as it was such that the government could not support the discussion of a very a complex legal situation on the floor of Parliament. The NDP motion, perhaps conveniently, left out two class actions, which, if properly resolved, could potentially result in more money being paid out to those children who suffered the most. Our main objection with respect to the CHRT is that it does not exist in a vacuum. There are some very basic legal principles at issue. One, in relation to the award to all children in relation of the time spent in care and harm suffered. We do not deny that harm was suffered. We do not deny that the systemic discrimination exists. I would highlight that not a single child has had to testify as part of this, and that's important. We do not want to re-trigger and re-traumatize. I understand that now the children in issue are now much older, but still these are events that can re-trigger and re-traumatize. So it's very important to proceed in a respectful way. We are looking for a global compensation model that will treat children fairly, equitably, and justly, and that is why we believe that this is best settled in the class action forum that was conveniently left out as part of the motion, and ask the government to take action on two particularly complex legal issues, one with respect to which there is a lot of missing context, a context that could potentially compensate children more, and the second with respect to the St. Anne's settlement, and I would highlight there that over 90% of those claimants have been compensated, but the destruction of documents that was ordered by the Supreme Court, and if we were to proceed as we are proceeding now, it would put us in a position potentially of contempt of court. These are complex matters. I get that they are very frustrating to people, but this government is resolutely determined to settle these matters in a proper and respectful way. And foremost, when I reflect upon the motion on Monday, I see it as the government letting its members speak and abstaining on issues where there are intense, complex legal matters out of honesty and integrity. I feel somewhat sickened as a politician to see conservatives knowing that something is non-binding, knowing they have to do nothing, and then with the other hand, trying to vote down the United Nations Declaration on the Rights of Indigenous People. So perhaps Monday wasn't a great day to be a politician.
Christy, do you have a follow-up?
Yes, thank you. And I appreciate I'm asking you about technical legal questions in the context of a press conference, and there's some limitations around that. But one of the central themes that has come up with respect to the Canadian Human Rights Tribunal and the respective orders, and I know there have been several of them and they're different in nature, but one of the central themes is this question of legal authority for the tribunal as a quasi-judicial body to issue orders, if you will, for the federal government to take specific actions. Can you just explain for Canadians what is the central legal question for the government with respect to the tribunal's legal authority, and how would you respond to the criticism that this is not a matter of legal technicality and just a means for Canada to resist paying the compensation?
Well, to the very last point, Christy, the order to pay itself was only issued a couple months ago, yet there has been a convenient narrative that we are dragging children to court and refusing to pay for some time. We have been in complete compliance with orders as they have come out, and this has been transformative for children. So I don't want to sit here and denigrate the role that the Canadian Human Rights Tribunal has played, because they have played an instrumental role in moving forward issues of discrimination, historical times and present. It is very important. It has pushed and guided the transformative change to ISK. It is pushed the recognition by the Canadian government that we have to do better and move towards substantive equality. That means doing what we do now much better and transforming the system, but also compensating for people for past harm. And let me be entirely clear. We know that transforming the broken child welfare system in Canada, which is ongoing in many ways, will take full partnership of provinces and territories, is going to cost billions, but will save lives. And that is what we are trying to achieve. There is an important element that you're talking about in and around compensating children. And we have said time and time again that we will compensate those in a fair and equitable fashion. But it is very difficult to look at the CHRT tribunal, which can only award a maximum amount of $40,000. And it did so, we argued, in a way that wasn't proportional, in a vacuum. And that is the subject matter that will be discussed principally in the court proceedings next week. It is not a refusal of the government of Canada to pay fairly and equitably and continue to move on transformative change, because there is not a single order that any tribunal in the country can issue that will completely fix the system. Fixing the system will be achieved through communities lifting up their own jurisdiction, recognizing self-determination. There is a real issue in and around capacity and some very, very dark, painful discussions that will have to continue in and around poverty, discrimination, mental wellness, families that will have to continue, but on the pace of families and communities and First Nations and Inuit and Métis people.
Thanks, Christy. Do we have any questions in the room?
Morning, Minister. Teresa Wright from the Canadian Press. I'm just going to pick up on some of the things that you were saying with regards to the CHRT ruling and the abstention. Generally speaking, people, MPs and ministers would abstain from a vote if there's a personal conflict of interest. So, and I know you mentioned that there was a potential contempt of court. Can you explain how a non-legally binding motion would somehow, result in a contempt of court? And also, you've talked about how the class action lawsuits were not included in the motion, and that those could result in higher compensation for First Nations children. Explain why the ruling from the CHRT and the class action are mutually exclusive. Why can't both of them exist? Why can't you award damages in response to the CHRT and also in the class action?
Yeah, and Teresa, you put forth, what I think what lawyers would say to me, which do whatever you want in Parliament, but it's non-binding, so you don't have to do anything. I'm not putting words into your mouth, but we did look at this and say, this is non-binding, so you don't have to do anything. And And that's the wrong answer to give Indigenous peoples. As a member of government, I have a particular duty that is grounded in honesty and integrity. And you have to look at every single word in that motion. We supported that motion 99% as a government. But there was an element around the complex legal nature of the court proceedings in and around the CHRT, knowing that we could not cease the legal review, knowing that in terms of what the Supreme Court has issued in the St. Anne's ruling, that we had to destroy evidence in relation to the independent assessment process, where individual people could then petition and say, we want them preserved, that had very, very sensitive information, issues around confidentiality, privacy, the documented abuse, sometimes abuse of an awful nature that petitioners perhaps would want destroyed. That is a very, very complex set of facts that the Supreme Court has ruled on. Now, I know Minister Bennett has taken action to appoint Ian Pitfield to review these things, but putting that forward to the public and saying we have to therefore preserve them and put the government in a position potentially of contempt of court is an issue in terms of the motion. And in terms of the CHRT ruling, knowing that our view is that the award did not take into account time and care. And if you look at time and care, and if you look at the prior settlements, they go on a spectrum, if you were to follow precedent, that at times, particularly for exceptional harm, and there are models to establish that we do our absolute best not to trigger and re-traumatize, that would go well above $40,000. So we have fundamental issues with the CHRT's ruling, with its assertion of jurisdiction, without denigrating some of the great work that's been done, and those are issues that will be argued in court next week.
I guess, and I'm not trying to simplify a very complicated situation, but, to everyday Canadians, you're saying on one hand, we want to compensate First Nations children, and on the other hand, you're in court with them. How do you square those two things? How does that not come across as hypocrisy?
Well, first and foremost, again, during the CHRT proceedings, there has not been a child that has been asked to testify. I think that's important because the public narrative has perhaps portrayed it as that. And our objective as a government is to we've recognized the systemic discrimination in the childcare system, and we want to compensate people in a fair and equitable way. We feel the forum that was chosen in the CHRT was one that was, the government didn't go to court, we were taken to court. Those are people's rights, and we respect them, obviously. But we have fundamental issues with the ruling, which is an issue of procedural action that, if properly established, and if the court that is reviewing it properly establishes that there has been a violation of procedure, won't prevent us from moving where we think this is the proper forum, which is the two. And again, there are two competing class actions, which can be puzzling to many people.
I'm just saying that there's
we have to distinguish between a court has limited jurisdiction. In the case of the CHRT, it can only award up to $40,000. It is by definition and by circumscribed by court, by case law, and by the Constitution, limited in its jurisdiction. We feel that it exceeded it and employed principles that weren't reflective of basic elements of law, proportionality, et cetera. When it comes to courts of general jurisdiction, like the courts that the two class actions are seized of, those are courts with much more discretion that are administered by judges, and they are ones where we think there can be more procedural fairness and potentially, in some cases, as I've mentioned, higher awards if you look at the precedents and the settlements that this government has moved towards. I think we have to recognize that this government has moved quickly and swiftly to settle cases. And we all know that when people lawyer up, things tend to take time, but the preference of this government is to settle things outside court. I have much difficulty discussing this publicly, but I think Canadians do want to know, and based on your questions, I think they should know. But I am limited in some of my responses because there are discussions ongoing, and they do remain confidential.
Thanks, Teresa. Operator, next question, please. Prochaine question, s'il vous plaît.
Thank you. Merci. La prochaine question, the next question is from Annie Bergeron-Oliver, CTV National News. Please go ahead. Your line is open. Votre ligne est ouverte.
Hi, thank you for taking my question. At the beginning of the pandemic and throughout, a number of Indigenous communities closed their land borders, implemented quarantine measures and other isolation measures to try to keep their community safe. You talked today about the rising number in terms of vaccination rates, as well as the declining number of cases on reserves. I'm wondering if you can tell me what it looks like in terms of communities, how many of them still have these types of isolation measures, and whether as different provinces start reopening, if we're starting to see Indigenous communities slowly relax some of those measures as well.
Yeah, a little bit of both, Annie. I based on the numbers that I spoke to this week and last week in particular, Indigenous communities writ large are ahead of the curve, and it's a good thing, and perhaps not such a good thing. There are high youth populations, and we've seen the outbreaks in the north. We've seen people in the large mass of unvaccinated youth, 18 and under, and now thanks to the Pfizer deployment of the vaccine, 12 and under, getting COVID. And so the lesson we can take from that as a country is that we're not out of this yet. I know provinces and territories are eager to relax their public health measures, but we're not out of the woods yet. And I can see that trend occurring among the unimmunized, particularly when we see things like the Delta variant, which is more infectious, continuing to take hold. And that is an element of some worry. There is good hope with respect to getting that second dose into arms, as we're hearing from everyone, and that's why I mentioned today the 40% number of folks that have gotten the second dose, because it will be key. First and foremost, the point of getting vaccinated is to reduce mortality and grave onset of the illness. So, in terms of the relaxation of public safety measures, our message is one of great caution, given the trends that we're seeing in Indigenous communities among the unimmunized, given the fact that as we compare to the non-Indigenous communities in Canada, there are larger proportions in many communities of youth populations. So we'll have to tailor strategies to make sure that they get vaccines. So that is an element of some worry to me, and I think a warning signal for the entirety of the country, because we know when the public safety measures get relaxed, that the first people to suffer are those that are the most vulnerable. We know that there are lower in youth populations, but we still don't know the long-term effects of COVID. So it's an operation, a very, very delicate operation in risk management. I'll pass it to Val to give you sort of a lot of the measures are still in place for them in the communities, but a lot of them are relaxing as well. Manitoba, Alberta are still considered hotspots. So our message to them is one of vigilance, but I think Val can complete the more technical aspects.
I would just say that, we do track on a weekly basis how many communities still have at least some form of border closure or, some form of more stringent public health measures. And certainly about 440 communities as of last week still had those measures in place. And I think we would certainly encourage communities to consult with medical officers of health on their recommendation with respect to what should be the target of vaccine coverage among the adult population, as well as the 12 plus, prior to easing those public health measures. Where we are seeing outbreaks now in communities, communities are very quick to implement very stringent public health measures, but there are some situations where they do see compliance challenges, and also their staff are quite tired. People have been responding to this pandemic now for a long period of time, and it does not take a lot for community resources to become depleted. And while we do have surge capacity to offer, it's also part of the consideration for communities when they're looking at easing public health measures. What is your surge capacity that you have in place or with partners, just in case you need it and you need to act very quickly?
Do you have a follow-up, Annie?
I do. So sort of along the same lines, the government is expected to announce in about an hour that there's going to be a loosening of quarantine restrictions when it comes to fully vaccinated travelers. And I know that there are a number of Indigenous reserves that straddle the U.S. border. Akwesasne, for example, I know that they have an exemption, but I have read some other stories about Indigenous Canadians trying to go across the border and having some challenges. So I'm wondering, what type of change do you expect today's loosening of sort of quarantine measures and hotel quarantine will make for Indigenous people? Do you hope it'll make it easier at the border, that they might not have to go through as much sort of hassle to be able to cross for necessary means?
Yeah, and what we've seen, frankly, throughout this pandemic, Annie, is when we work with communities and we don't sort of high-handedly impose things, they've sort of done a better job than us in keeping their people safe. That's, Akwesasne, it was throughout, first and second waves was exemplary in some of the work they did, and they have a territory where the border was imposed on them, and so that border is more than a headache. It's the lived reality of people going back and forth to soccer practice, lacrosse game, and it is an element of some frustration. So that is the reality of many communities. It's one that you can't escape any discussion without talking about without rights and the inherent right to travel across their homelands. And so that always has to guide our conversation when we're talking about this. We know that with respect to Indigenous peoples, ever since 9/11, there has been a tightening of evidence you got to produce to cross the border, and Indigenous peoples have been directly impacted, not just people that have communities on the border. And so that is a very, very delicate consideration when we look at evidence of vaccines. And I would say Indigenous peoples don't have generally any problem with getting vaccines. They just sometimes have an objection to the form of documentation you have to produce to do something that they feel they're entitled to do. And so that's, again, it'll require a number of conversations in those communities that are directly impacted. But we always strive to work with CBSA to make sure there is cultural sensitivity as they deal with cases of Indigenous people crossing the borders from the U.S. to Canada.
Thanks, Annie. Operator, last question, please. Dernière question, s'il vous plaît.
Thank you. Merci. The last question, la dernière question is from Boris Proux, Le Devoir. Please go ahead, your line is open. Votre ligne est ouverte.
Bonjour, merci de prendre ma question. Elle concerne le 27 millions de dollars qui a été annoncé mercredi de la semaine passée, si ma mémoire est exacte, pour des fouilles, 27 millions de dollars rendus disponibles aux communautés pour les fouilles similaires sur les pensionnats, les anciens pensionnats. Il semble que ce 27 millions de dollars-là n'ait pas été inclus dans la loi de mise en œuvre du budget de 2019, ni dans aucune autre demande de crédit budgétaire au Parlement depuis. Donc, ma question est la suivante. Est-ce que vous allez inclure cette somme dans une demande de crédit budgétaire dans le futur?
Merci, Boris. La somme présentement est disponible. Ça se peut que ça ne soit pas assez, évidemment. Ce que je veux rajouter, c'est que vous avez parlé de fouilles de recherche, mais il n'y aura aucune fouille ou recherche sans le consentement des communautés en question. Et évidemment, étant donné les droits et puis la question immensément sensible de fouilles, d'enfouissement, puis très sensible pour les communautés qui vivent encore des moments très pénibles, comme à Kamloops, mais partout au pays. Et donc, cette somme sera disponible. Elle est disponible dès maintenant pour les communautés qui le désirent et qui prendront ce choix de procéder à des recherches plus approfondies des sites de pensionnat. Il y a une complicité, évidemment, qui doit être effectuée avec les provinces et les territoires. J'ai les assurances du ministre Lafrenière que ça sera le cas dans le cas du Québec. Mais ça prendra un travail, évidemment, d'équipe et nous sommes en train d'établir quelles communautés au juste ont besoin de fonds immédiatement et de respecter à la fois les communautés qui feront ce choix dans l'avenir. J'ai eu plusieurs appels de leaders de communautés qui ne sont pas prêts à faire ces recherches, mais ils veulent l'assurance en même temps qu'il y aura de l'argent s'ils prennent cette décision, le cas échéant. Donc, il y a une certaine dynamique qu'il faut respecter, mais une dynamique qui est axée d'abord et avant tout sur les désirs des communautés en question.
Avez-vous une question de suivi?
Oui, merci pour la réponse, mais j'aimerais quand même savoir, quand vous dites que vous avez rendu la somme disponible, si vous l'avez prise à même quel budget, parce que les sommes n'ont pas été encore votées en crédit au Parlement. Donc, peut-être vous pouvez m'éclairer sur où vous l'avez pris.
Bien, la somme a été annoncée dans le budget 2019 et ça a passé, si je ne m'abuse, le Conseil du Trésor très récemment. Donc, la somme est disponible. Pour l'histoire de crédit, puis de tout ça, je pourrais faire les recherches pour vous, mais je vous assure que c'est disponible.
Merci, Boris. Cette question conclut la conférence de presse. Merci. That concludes today's press conference. Thank you.